Yeah, hi everyone. Thank you for the introduction by Shireen. I'll go straight to the topic that I'll be sharing today. I hope that this will just be a sharing. I'm not advising. I'm just sharing the what is actually the amendments to the Employment Act. And for some of us, we may be familiar. For others, I think if you are not familiar, I think it is also sure. It is also very important to, sorry, yeah. I will just start to share screen. Can you see? Yes. Okay. All right. Okay, I'm going to talk about the amendments to the Employment Act. For some of you all who have been following the news, this implementation of the new amendments to the Employment Act supposed to have started this month on the 1st of September. But as you all have read in the news, because of some lobbying from certain sectors, particularly the employers, some corporations, some chambers and some industry, as well as the unions for the employers, they wanted it to be delayed, and we did get their wish got granted, and it will be delayed until the 1st of January 2023. So it's basically something that is inevitable, but okay. Sorry, we are sharing screen in the Zoom. Yeah, for those Zoom, sorry, I know we are trying to share the screen as well. So, yeah, so. All right. Okay, I hope those watching online will be able to see the screen as well. So what I was saying that it's inevitable, so it's going to start on 1st of January, and there are major changes to the Employment Act. How it affects us is that if you're an employee, with the new amendments, it will affect you, every one of us. If you're an employer or business owner, it will affect you, and in fact, to some, it will affect the business owners more than the employees. So basically, it covers everyone. I'll straight go on to the amendments, where we talk about the definition of an employee. Under the old law, as some of y'all may be aware, any person who has entered into a contract of service and his or her wages are 2,000 and below, they come under the Employment Act. So previously, those people who earn more than 2,000 ringgit a month, they do not come under the protection of the Employment Act. So their employment protection comes from the contract they actually sign with their employers. But with this new amendment, it covers any person who has entered into a contract of service. So now, it actually avails the protection. Echo. Yeah. Now it. Okay. Okay. Now, under the new law, it actually covers everyone, except there are certain exceptions where the provisions of the Act is not open to those earning 4,000 and above. So if you're 4,000 and above, apart from those exceptions that were listed under the amendment,
you're also under the protection
of the Employment Act.
so it covers all. So I'm going to go to the next slide. Okay, these are some of the
provisions in the Employment Act. While it has opened to all that has a contract of service with a company, but they earn 4,000 and above. These people are still not entitled to overtime payment, like for work on rest days, work outside normal working hours, for work on public holidays, as well as work on half working days. And in respect of benefits, they are not entitled to shift work benefits, termination, layoff, and retirement benefits. Those under the Employment Act prior to the amendment, they're entitled to all these things, overtime payments, blah, 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 plus benefits and the protection. But now that it has opened up to everyone, but if you earn 4,000 and above, these are some of the main exceptions that those earning 4,000 and above are still not entitled to. That means if you earn 3,999, you're still entitled to overtime payment, benefits such as termination and layoff benefits and retirement benefits. So the major amendments I would touch upon, actually there are more than these, but the major ones includes these 8. First of all, it's on working hours, it's on sick leave, flexible working arrangements, maternity leave, paternity leave, sexual harassment, foreign worker rights, and presumption of a worker, or presumption, what is an employee? So the law actually provides for such changes that would affect everyone, both employer and employees. Okay, we start off with working hours. I'm going to talk about before and after. Prior to the amendment, the normal work hours of an employee may not exceed 48 hours per week and is subject to a maximum of 8 working hours per day. Otherwise, above that, overtime applies. But with a new amendment, the bill proposes to reduce this cap to a maximum of 45 hours per week. So anything above 45, those earning 4,000 and below, or below 4,000 rather, will be entitled to a claim of overtime. So this is quite major. Next, sick leave. Currently, the law provides that where hospitalization is necessary, an employee is entitled to 60 days of paid sick leave in a calendar year, inclusive of any hospitalization. With the new law, the paid hospitalization leave of 60 days would be treated separately from any paid sick leave, and an employee would be entitled to 60 days of paid sick hospitalization leave, plus the number of days of paid sick leave to which they are actually entitled to. So again, additional benefits, additional protection for those that falls under the Employment Act. And for some of this, of course, it only applicable to those who are earning below 4,000. Okay, this will be interesting. Flexible working arrangement. This came about because the Parliament were deliberating flexible working arrangement during the pandemic, during the lockdown. And it became law. And to some companies, it would be quite drastic. Because what it provides is that an employee may apply to an employer for a flexible working arrangement to vary the hours of work, days of work, or even place of work in relation to his or her employment. So this is quite major to some companies, although some companies are already practicing the hybrid, working arrangement, but not all. But when the law is supposed to have started this month, when it starts on the 1st of January 2023, there are such provision that is in the law that the employees can actually apply for such flexible working arrangement. How it works is that the employee makes an application in writing, and the employer either approves or refuses within 60 days from the date of such application is received. And the employer is supposed to state grounds if in a case of a refusal. So the employer cannot unreasonably refused an application for flexible working arrangement, failing which the employee can actually lodge a complaint against the employer. Okay, we move on. And the provisions on the flexible working arrangement, if we have followed the law, it has been watered down compared to the original proposal raised during consultation of this particular bill. Okay, the reasons for refusal on the second part where the employer has received an application for flexible working arrangement are not provided for under the bill. Okay, it remains to be seen. Of course, this will be tested subsequently in court if someone complains to decide what is unreasonable when you refuse such requests or application to work in a flexible manner. Okay, this will be very interesting, of course, for both men and women, for those who are married or those who are working moms. Currently, rather than before, it's currently 60 days of maternity leave, and this is the provision that applies to all. So even currently, those who earn more than 2,000, this particular provision applies to everyone. After the amendment, even those earning more than 4,000, this also applies. And with the new law, maternity leave is going to be extended to 98 days, in line with the previous budget announced by the government. Before the law was enacted, they already said this is what they plan to do, which they did. And the bill makes it an offense. This one is something new. The bill also makes it an offense to terminate the employment of a pregnant employee, except on grounds relating to misconduct, willful breach of the termination contract, or closure of business. So under only these three limited circumstances, you can actually terminate a pregnant employee. The current law, they talk about terminating someone who is entitled to maternity leave, the current law. But from 1st January 2023, you talk about committing an offense to terminate someone who is pregnant or as a result of pregnancy, any illnesses related to pregnancy, you cannot terminate that particular employee, failing which you will commit an offense. Move on. Under this termination of pregnant employee, the burden of proof lies with the employer to prove that the termination is on grounds not of pregnancy, nor illnesses arising out of pregnancy. So again, it imposes extra burden on the company to prove that if someone pregnant and gets terminated, it is not on the grounds of because she couldn't work because of pregnancy, sickness because of pregnancy, and so on and so forth. So extra burden on the employee. So I can see some potential effects. While the aim of the amendments should be viewed positively, okay, this will certainly affect businesses that may wish to pursue a genuine redundancy or retrenchment exercise, which may involve a pregnant employee amongst all other affected employees. The statutory exceptions permitting the termination of a pregnant employee are rather narrow. So if you recall, there are only 3 restricted reasons that you can terminate a pregnant employee, one of which is some willful breach of the contract, some serious misconduct, or closure of business. But sometimes when you do an exercise of retrenchment, you don't necessarily have to close down your business. You may actually reorganize, or you may outsource, or you may even close certain divisions, but not necessarily your whole company. But it seems that you can only retrench a pregnant employee if you're closing down your company. So it's actually very restrictive. So if you are a business owner, this obviously will actually affect how you run a business. Okay? Okay, this one is interesting for the men and for fathers. The bill proposes that for a married male employee to be given 7 days of paid maternity leave in respect of each confinement, up to a maximum of 5 confinement, irrespective of the number of spouses. So the last portion is not applicable to all. Okay? Certain people can have more than 1 spouse. Okay, but up to 5, they can have a paternity leave of 7 days. and it will become law from 1st January 2023. Okay, the next one. Okay, conditions of paternity leave. Okay, you must be employed with the same employer for at least 12 months before the commencement of such paternity leave and has notified his employer of the pregnancy at least 30 days from the expected confinement or as early as possible after the birth. Okay, this is provided under the Act. Okay, this one is a new provision. Under the existing Employment Act, we do have a provision for sexual harassment, protection for sexual harassment. However, this comes as new. It says that the bill requires employers to exhibit conspicuously a notice to raise awareness of sexual harassment at workplace. It also proposes to increase the penalty of an employer's failure to inquire into sexual harassment from 10,000 ringgit to 50,000 ringgit. So the current law provides for, it imposes on the employer to investigate when there's a complaint lodged on sexual harassment, and they're given time to revert, to properly do an investigation and so on and so forth. But the new law has actually further strengthened it, actually as perhaps a deterrent or create awareness or create advocacy on sexual harassment. You even have to have like a charter, a notice to raise awareness, maybe in a handbook, or even put in your offices to say that we commit to ensure that it's a safe working environment and we do not tolerate sexual harassment that happens in any organization. This is employment of foreign workers. There is also some changes here, and this particularly was one of the reasons that many Chamber of Commerce and industry that actually fought for or lobbied for the enforcement of the Act to be delayed until the 1st of January. Because under the new law, it says employers must obtain prior approval from the DG of Labour to hire foreign employees. Failure to do so constitutes an offence, and on conviction, the employer shall be liable to a fine not exceeding 100,000 and or imprisonment of not exceeding 5 years. And we know in Malaysia, we do have foreign employees that may not have gotten the approval of the Director General of Labour. And of course, hiring foreign laborers at the moment also creates a problem to many organizations, especially those with large factories or plantation and so on and so forth. So that was one of the reasons why the minister actually also said that we gave in from the requests and lobbying from different sectors to delay the enforcement of the Employment Act. Okay, this one is also another interesting amendment that will affect many industries and many companies as well. Now, the Act provides for presumption of employment. Okay? What it provides is that the bill provides that unless proven otherwise, an individual shall be presumed to be an employee if 5 of these conditions: his manner of hours, his manner or hours are subject to control or directions of another person. He's provided with tools, materials, or equipments by another person to execute his or her work. Payment is made to him for work done at regular intervals, and it constitutes the majority of his or her income. His work is performed solely for the benefit of another person. His work constitutes an integral part of another person's business. Okay, this is to capture those perhaps who is currently doing MLM, multi-level marketing. They're doing certain types of sales, and even those e-hailing drivers. You see, if they come under all these conditions, the company can no longer term them as independent contractors or casual workers or people that provide service without benefits as an employee. So the law has been amended to ensure that everyone is presumed an employee until and unless the company disprove these factors to say, I have no control of this person, or I don't provide tools for this person in his trade, and he doesn't just work for me alone, or his work does not constitute an integral part of my business, or his work is performed not solely for me. So think about it. It may even include agents in certain industry, like unit trust, insurance, and so on and so forth. So it's actually quite wide-ranging because it changes the legal presumption of an employee as opposed to an independent contractor. It imposes a presumption that distinguishes what are real independent contractors or what some employers rather not have someone attached with the company so that they do not have to, consider paying social security like EPF, SOCSO, and so on and so forth. And some employees, or so-called employees, would rather consider themselves signing a contract for service as an independent contractor so that I don't have to fall under certain restrictions of the company, like disciplinary processes and so on and so forth. So in Malaysia, is actually in many countries as well, now with the gig economy and so on. So you have a lot of people consider themselves our bosses, you run your own business. But at the same time, many of them are also controlled by the company, if you have realized. Okay. Do I have any more slides? Okay. So those are my slides. I'm not sure whether I have almost, is it almost time? Yeah, okay. Thank you, everyone. Yeah.
Right, let's join me in thanking Leonard for that very enlightening talk. So if you join me here for a Q&A session. Okay, thank you, Max. Okay, for those of you who are online, please feel free to share your questions on the chat box, and we will address the questions by asking Leonard. So we have entered the Q&A session, and so both of our audience on site and online, please feel free to share your questions with us. So Leonard, do you actually support the flexible work arrangement for your own law firm?
It depends. Okay, I think it's something that we also discussed about, within our own company and partnership, that it is something that we cannot avoid because I think moving ahead, most companies are moving towards either full flexibility or, a hybrid situation. And in such a situation where even the law imposes or made available such options where the employee could actually apply to have flexible working arrangement, I think there should be a mindset shift, by all business owners to really consider, is it really that bad if people do not come into the office? It's just sometimes the stigma of when people is at home, they may not give their full attention and time, and yet you pay the full salary. Those type of mindset. So I think it's just something inevitable.
Yeah, and I think a lot of millennials coming in for interviews actually ask whether that's one of the benefits that provided with the company. So yeah, flexible work arrangements is going to be part of statutory law starting from next year. So I'd like to invite those online and on site again. If anyone has any questions, please feel free to share. Okay, Max has questions. Can you pass the mic to him?
For the last slides that you showed earlier, the 5 presumptions that you have listed, do you need just one or everything in it in order to consider to be an employee?
Okay, first of all, these are factors to be considered. Since it's a new law, it hasn't been tested, but currently, though it is not statute-based law, we have already decided cases. We call it common law. Common law, we already have cases to actually differentiate whether they are actually genuine independent contractors or this test has already, you see, most of this that you see as part of the new laws, they have already gone through perhaps many case laws in court. But all these enactments, the parliament is basically compiling everything what is the most reasonable, and they make them statute-based. So even currently, there are already laws which provides for all these factors for the court to consider. So now that is now stipulated in the statute, it should be setting the same standards as well to say that you have to consider all, not just one, just control alone, then that's it, you're an employee. It's just like, let's say you've got an insurance manager, telling the insurance agent or whatever, say that you have to come for morning briefing at 8 o'clock. That is control, but that alone, does it mean all agency agents are all employees of the insurance company? So not necessarily. So you have to consider all the factors and weigh all these factors, and only if it is being challenged, because some of these so-called independent contractors, they rather remain as an independent contractor, you know what I mean? Because once you're an employee, whatever they used to call it like commission now become wages, you have to pay EPF, and you have to, there are more restrictions. Some of them may not even want that, you understand? So, but the government wants this actually is to protect them, because there's other industries, really, the company is basically engaging people, but they just do not want to give them any of this protection as an employee. So they rather term them as independent contractors. Yeah.
Right. Okay, we have another question. Can you pass it in?
Hi, Jason here.
Hi, Jason.
Good to finally meet you.
You're from?
PwC.
Oh, yeah. Hi.
Yeah. So, quick question. On the sexual harassment, right? Since the employer is supposed to produce some kind of explicit notice, is there any guidance, on this by MOHR or?
Actually, there's no guidance yet because the law has not come into force. If it has started on the 1st of September, then, sometimes what happens is that the minister may announce certain things, or there are certain further regulations that, the subsidiary legislation will come up with guidelines, or the ministry itself will come up with certain guidelines to say that, it has to be, because the word use is conspicuous, so it has to be quite obvious lah. So to some, it could be defined as in the handbook. And if the handbook is available in a shared drive, and when someone comes in, they sign on the handbook apart from the employment contract, that is conspicuous enough to say that, this is no sexual harassment being tolerated in the company, or no sexual harassment policy, those type of things. But of course, to be on the safe side, of course, do prepare some notices just in case, but nobody knows how they're going to enforce it. Yeah, because the prior amendment to the Employment Act actually provides for investigation of sexual harassment that makes it an offense if the employers do not actually, institute an investigation after a complaint is lodged. So this one is actually just to further enhance it. Okay.
Right, so I think it's supposed to be somewhere conspicuous.
Yeah.
That the notices have to be clear, conspicuous.
Yeah, maybe next to the signboard, or maybe in meeting rooms, like, okay. But we will know when it comes 1st January, because it's an imposition that all companies have to do it. So we have no choice but to do it. Unless someone complains, then you see how law develops is that you could put it in a statute, but everybody is second guessing what if it is not very clear. But when it is tested in court, when someone lodges a complaint, then the judges start to further expound and expand the law so that we understand what it meant, what Parliament meant by, they say, conspicuous. So the judge will have to basically decide the case to say what is conspicuous, perhaps 1, 2, 3, 4, or something like that, right? Okay.
And I think when it comes to sexual harassment, it's also a question of where do you draw the line. And that's probably another topic which we need to invite you again. But let's move on. So with these new amendments to the bill of the EA bill, how do you think this would impact the business landscape in Malaysia? Is it going to drive up the cost of goods, lower our attractiveness in terms of FDI amid mostly stagnating wages?
Okay, it's a very broad question, but just to touch on what is more obvious is that obviously it will increase costs, but at the same time, it may actually reduce productivity at the same time. If you look at some of the benefits that has been enhanced, including the length of maternity leave, and never before in law the paternity leave, that means for those who are, who has given birth, and for some employees in some organization, maybe once a year or once every 2 years. So the length of working will be substantially reduced, but at the same time, the cost has actually increased. So what it means is that operating costs will increase, productivity may even go down, which goes against the whole spirit of having to, increase the, we want to achieve high earning nation or high income nation, but at the same time, we want all the good, but not the consequences when there are good. There should be some balance. So what I've always tell people is that in Malaysia, my advice has always been, it's very cheap to hire, but it's very difficult to fire. So cheap hiring, expensive firing. But with the new amendments, it's going to be expensive hire, expensive fire. In a developed country, in a first world country, it is expensive to hire, but it's not so expensive to fire. It's expensive to hire, not so expensive to fire. Because in other countries, developed countries, we have what we call a term employment at will. In a first world country, we have employment at will, where you can terminate any employees if they are not performing well, based on a contract and be given notice. But many people in Malaysia do not know we have what we call a security of tenure, where you cannot simply fire your employees, even if they have performed badly, but you can only fire them after you are able to prove that, with just cause or excuse, and all the processes, all the procedural processes, you have to go through it before you can fire someone. That's why a lot of multinationals, a lot of foreign investors, when they come in, they didn't know, they think it's cheap to hire, but they realize the firing process would equalize everything. So it's not so attractive coming to Malaysia in the first place. So if now hiring is expensive, maintaining an employee is expensive, then it's going to be a double whammy. So now it's so difficult to maintain employees, and firing is almost an impossibility, for those in HR and for those, who are business owners, and some of us have also learned our lesson, because we don't comply with the way you fire someone, then you pay heavy when there's a complaint lodged at the Industrial Relations Department that, that goes on to be heard in industrial court, and then awards are awarded against the company.
Yeah, okay. So we learned about the security of tenure. So for all the employees who are here on site online, good news is we have job security. For all the employers and business owners, well, sorry, it's very hard. It's very cheap to hire, very expensive to fire. So I think the moral of the story is hire prudently, and make sure you have stringent and robust processes in place so that you hire right. I think you agree with that.
Yeah.
So I think it's very interesting also that you mentioned about an extended pregnancy leave. Maternity leave, not pregnancy leave, 98 days, right? And so one of the implications of that is that it may cause some disadvantage to women of childbearing age, because when you come for an interview and you're married and you have the potential to get pregnant, right? So, and anytime you can go on a 3 months leave, and that would hit productivity. So I think that's what we discussed as well. And so it will make women of childbearing age a less attractive candidate in interviews. That's not very fair, right? Don't you think so, for the women here? So I'm just thinking, why can't they make it an equal maternity and paternity leave? You might think that's pretty radical, but I'm telling you, there are some MNCs that have that equal tenure of both maternity and paternity leaves.
I don't think any employee will complain about that, but you must also think about the business owners. And if you look at the paternity leave, they could actually claim up to, five child with, even though different spouses. And can you imagine for the first 4 years, if let's say you're a fresh graduate coming into the workforce, and you being an employer hiring someone like that, instead of paying that employee 12 months, the person only is working for 9 months or 9 months, or less than 9 months, because 98 days, right? So it's 8 months plus, and it's going to be a heavy toll on the business owner or the company. Just try to imagine if you're a startup, you start up a company, and this type of things will really discourage you from expanding, or discourage you, but even land in Malaysia. It will definitely affect the FDIs. Then coming back to the maternity one, I agree that with this a new legal imposition of 98 days of maternity, all things being equal, okay, it may not sound very fair, but for an employer, if they have a choice, really all things being equal capability, equal personality, equal everything. But if the employer thinks that if I hire a male, the most paternity leave is 7 days, but maternity is 98 days. And if the employer chooses to hire a male over a female, we don't have such discriminatory laws, unlike some other countries. So ended up, perhaps as you got more maternity leave, but the female childbearing employees may be less marketable when it comes to decision of whether to hire an employee. Yeah.
Right, yeah, thanks for that. I mean, I know it's radical, but yeah, it just puts us on a level playing field. But never mind, we can work with that. We just, I guess, have to work harder lah to prove our productivity. But I'm just also interested to know, because this enactment has some really broad-ranging implications to even the gig economy workers. So I'm wondering, does it cover the undocumented migrant workers as well? And how does it impact them?
Okay, this one is a very interesting point. To me, my personal view is that it shouldn't, because the engagement of an undocumented worker means you're actually engaging someone illegal, right? Someone undocumented actually could mean those who have expired their work visa, or including those people who actually, they're boat people, they just came and then they're undocumented, or they could be from another industry and then they escape, or they could be those domestic workers who went on to, after the expired visa, they ran to work in the restaurants. These are undocumented workers. To me, it wouldn't be fair for them to get such protection, because there's a concept in law, in contract, that illegal contracts are not enforceable, and illegality actually voids a contract. So an employment contract is also a contract. So if your position on the legality of your status in a country is already illegal, so how can that be fair for them to be accorded such protection? However, recently, in fact, it was this year in March, the Court of Appeal in Malaysia actually decided, it was pursuant to an appeal to the Court of Appeal, where a domestic worker, now under the new law, they're going to be called domestic employee. Basically, they are domestic servants, yeah, who were owed wages up to 30,000. And she's actually undocumented. Basically, she's an illegal worker, but employer did not pay her salaries for many months, a few years actually. And she wanted to bring this to the labor court. And the employer actually argued, how can you claim against me? You're an illegal immigrant. So how can the law actually enforces an illegal immigrant's claim? Because the claim technically supposed to be someone who's entered into contract of service. But how can an illegal immigrant enters in a contract of service? But the court decided that she should be, accorded such protection. And she actually succeeded in her court of appeal, on appeal, she succeeded to claim her 30,000 back wages, even though she was undocumented. I'm saying this is very interesting is because illegal immigrants does not just limit to domestic workers. It includes, those in the vice industry, including those like, in illegal gambling, casinos, and all those things without proper work visa. But sometimes we tend to judge them differently. It's like those domestic illegal workers, they should be protected, but those in other industries, they should not. We tend to argue that. But the distinction, of course, could be made that the industry that are in, like, in gambling, in prostitution, those are illegal business, so we cannot endorse that. But a domestic undocumented worker, they came in, do something legit, it's just that they are not legit. So maybe based on policy reasons, the court actually decided otherwise. But legally speaking, not supposed to, because if you are in the first place illegal coming into this country, you breach the immigration laws, why should, also based on policy reasons, we actually enforce and legalize their employment? This one, just my personal view. Yeah.
Right. Thanks for that, Leonard. And I think rumor has it that our illegal foreign workers actually outnumber our legal foreign workers by a lot, by a mile. And I think it's worth noting that a lot of them are also victims of human trafficking.
Yes.
So they work in the vice industries and a lot of 3D jobs, dirty, dangerous, and difficult jobs. So yeah, but it's reassuring to know that the court accorded that lady some form of protection, which could be a good precedent. So we have a question from one of the audience online. How does the new amendment affect those hired by companies like Adecco? I'll get to that later. Companies like Adecco and supply the employee to work to a company, meaning which is like a subcontracted human resource company that would second out
the manpower groups.
Second their employee out to a different company.
Okay, the good thing about the Malaysia's protection is that law has actually defined employers are not just limited to those whom you sign a contract with, and there are case law that says that there are also primary and secondary employers. So some companies, they try to avoid obligations and commitments to employees. They hire people from manpower groups, those third parties, employment agencies. And some of these employment agencies, I'm not talking about the one that you name. There are some which are really just $2 company. They are quite worthless in terms of assets. And when they are fired, the perception is that, but you are never my employee, including some large multinationals, because you are an outsourced employee from this $2 company. So if you want any claims, you go after that company, which is only $2. But the court in the past have actually decided that despite you sign a contract with the $2 company, but you're seconded, or actually you're hired by these multinationals, which thinks that they can escape responsibilities and liabilities, the court has actually found them to be secondary employers. And when they file for reinstatement claim, back wages were awarded against this company whom the person actually works in, not just the manpower or recruitment agencies. Yeah.
Okay, so thanks so much, Leonard. I think we have more questions online as well, but unfortunately we cannot take all the questions because we are running out of time. So could you all please join me in warmly thanking Leonard for a really excellent talk. Thank you so much, Leonard.
Welcome. Thank you.